The UDRP, or Uniform Domain Name Dispute Resolution Policy, requires trademark owners to prevail on all three parts of an important test. Previously, I've talked about the first part, which relates to trademarks, and the second part, which relates to rights or legitimate interests. The third part of the UDRP test relates to a cyber squatter's bad faith, and it's usually the most important part of any UDRP complaint. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to talk about the third part of the UDRP's three-part test, which requires a trademark owner to show that a disputed domain name has been registered and is being used in bad faith. But first, here's a reminder of the UDRP's three-part test. The first part of the test requires a trademark owner to prove that the disputed domain name is identical or confusingly similar to a trademark in which it has rights. The second part of the test requires a trademark owner to prove that the registrant of the disputed domain name has no rights or legitimate interests in it. And the third part of the test requires a trademark owner to prove that the domain name has been registered and is being used in bad faith. The trademark owner has to prevail on all three parts of this test to obtain the transfer of a domain name. In this video, I'm focusing just on the third part of the test. There's one especially important word in the third part of the UDRP's test, the word "and." Specifically, the language of the UDRP says that a trademark owner has to prove that a domain name has been registered and is being used in bad faith. Now, there's some interesting history in UDRP decisions through the years about the importance of this word, but the consensus view is that it means a trademark owner really has to establish two types of bad faith registration and bad faith use. This is important because it means that a trademark owner may fail to prove the third part of the test even if a domain name is currently being used in bad faith if it was not registered in bad faith, and vice versa. So this is an issue I always talk about with my clients, especially if a disputed domain name was created before a trademark owner's trademark rights arose. In any event, what is bad faith under the UDRP? The policy itself lists four different circumstances that are considered to be evidence of registration and use of a domain name in bad faith. But these four circumstances are just examples. In other words, these are not the only ways to establish bad faith, as I'll explain in just a moment. Here are the UDRP's four bad faith definitions. First, if a domain name registrant has registered or acquired the disputed domain name primarily for the purpose of selling, renting, or otherwise transferring it to the trademark owner for valuable consideration in excess of its documented out-of-pocket costs directly related to the domain name. In evaluating this definition of bad faith, UDRP panels often look at whether the registrant has threatened to sell the domain name to the highest bidder, whether the domain name is highly distinctive, or whether the domain name contains a typographical variation of a trademark. The UDRP's second definition of bad faith relates to whether a domain name registrant has engaged in a pattern of such conduct, that is, registering domain names to prevent trademark owners from acquiring them. In evaluating this definition of bad faith, UDRP panels often look at whether the current complaint includes multiple domain names, or whether the registrant has lost previous UDRP decisions. For this reason, I always explore the multiple UDRP databases and often conduct additional research to identify other domain names that may be associated with a specific cyber squatter to build the strongest possible case for bad faith. The UDRP's third definition of bad faith is whether a domain name registrant has registered the domain name primarily for the purpose of disrupting the business of a competitor. UDRP panels have interpreted this definition broadly, considering competitors to be any person who acts in opposition to another for some means of commercial gain, direct or otherwise. Finally, the UDRP's fourth definition of bad faith looks at whether a domain name registrant has attempted to create a likelihood of confusion by intentionally attempting to attract internet users for commercial gain. This definition is similar to the test for traditional trademark infringement under U.S. and other laws, and it may be the most common way to establish bad faith under the UDRP. Often, a likelihood of confusion may be implied if a domain name is identical or confusingly similar to a famous or well-known trademark. And certainly, websites that sell competing or counterfeit products or domain names used in email addresses as part of phishing schemes all may create a likelihood of confusion under this definition of bad faith. As I said earlier, these 4 definitions of bad faith are non-exhaustive. In other words, a trademark owner can establish bad faith even if a domain name registrant hasn't acted exactly according to any of these definitions. So through the years, UDRP panels have found bad faith in many other circumstances. But perhaps one of the most common is what is referred to as the passive holding doctrine, which occurs when a disputed domain name is not actively being used at all. While it may seem counterintuitive at first to think how an unused domain name can be used in bad faith, panels have said that the totality of the circumstances may indicate bad faith. This concept of passive holding is very important, and I explain it in detail in another video. Establishing bad faith is just one requirement under the UDRP's 3-part test, but it's often something that requires the most time and attention. When I draft UDRP complaints for my trademark clients, I usually look for facts and legal arguments to establish bad faith under multiple theories, giving a UDRP panel several opportunities to find bad faith and transfer the disputed domain name. I also try to anticipate potential defenses that a cybersquatter may present and proactively argue why these do not negate a finding of bad faith. In my experience, this is an important way to help ensure success on the 3rd part of the UDRP's 3-part test. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you.